Feeling lost in the maze of CPS? Desperate to get your child back? You're not alone. Countless parents face the heart-wrenching reality of family separation. The legal system can be overwhelming, but there's hope.
Now, here's the key. Okay, that's how you win a 6-month hearing.
Thank you.
If you do all of those things, you're going to blow your social worker's mind, you're going to blow your attorney's mind, and you're going to blow away the judge.
With attorney Vincent W. Davis, a dedicated legal expert with 39 years of experience, committed to helping families like yours. Join his weekly live Q&A on Zoom, where you can ask your burning questions about CPS cases. Get the knowledge and strategies you need to fight for your child's return.
Alrighty, good evening everyone. This is a question and answer session for school, SKOOL, and this is the CPS school.
Are you ready to take control of your family's future? Join our school community for free to access weekly live Q&A sessions, or participate as a one-time guest. Don't let fear hold you back. Take the first step towards reuniting your family. Join us now.
BAM! Good afternoon, Ms. G. How are you?
I'm good. How are you?
Good. So we're having office hours right now. What's going on?
Office hours. I'm still at office hours. I'm completing an agreement actually right now.
So what's going on? You have any questions for me today?
Yes, I do.
Shoot, let's go.
When, in your book, you mentioned the jurisdictional dispositional hearings sometimes can be handled, conducted together or separately, right? When they're conducted separately, why do you think there's a difference between together and separately? I want you to explain that to the audience because I got a lot of phone calls today about that particular question.
Okay, so first of all, the jurisdictional hearing and the dispositional hearing are two separate statutes. They're two separate laws in the Welfare and Institutions Code. The jurisdictional hearing is only to decide whether the allegations against you are true or partially true. And the evidentiary standard for jurisdictional hearings is a preponderance of evidence, and the test is whether you are a risk to the child. All right. The dispositional hearing is a hearing where the social worker must prove by clear and convincing evidence that you are a substantial danger to the child, and by clear and convincing evidence there are no less restrictive alternatives. Now, notice under a jurisdictional hearing they only had to prove risk. Under a dispositional hearing, they have to prove that you are a substantial danger. Now, if I look at a child the wrong way, I could be a risk, but I'd have to be one bad MFer to be a substantial danger to a child. Not just danger, substantial danger to a child. And it has to be by clear and convincing evidence, not by a preponderance of evidence in the jurisdictional hearing. And the best way to explain to you what clear and convincing evidence in terms of what preponderance of evidence is to explain the three types of evidentiary burdens in most states and in California. Mm-hmm. The top evidentiary burden that someone has to meet is something called beyond a reasonable doubt. Mm-hmm. And I equate that to mean they have to prove by 90% that something is true. That's the standard that is used in a criminal case. All right. Mm-hmm. The next level down is clear and convincing evidence, and I say that it's equal to 75% or more. All right. They have to prove something is true. The next level down from that is a preponderance of evidence, and that's more than 50%. Now notice, Preponderance of evidence is used in the jurisdictional hearing, and they only have to prove risk. In a dispositional hearing, they have to use clear and convincing evidence, and they have to prove substantial danger plus no less restrictive alternatives. Not too long ago in LA County, I won a case at the dispositional hearing, and the mother got the kids back because the department hadn't proven that there were no less restrictive alternatives. And this is a test that it's forgotten about by many attorneys in a case.
Mm-hmm.
So one of the less restrictive alternatives I suggested, and I had a witness there, the grandmother, to testify, that if the judge sent the kids home, she'd live with the mother to make sure everything was safe at the home. And I didn't think the judge was going to rule in my favor at the beginning of the trial. And I think that during the trial, she was convinced what the law was, that they had to prove by clear and convincing evidence that there was no less restrictive alternative. And I proved that there was. The interesting thing was, and it was kind of funny, I felt sad for the social worker. When I put the social worker on the stand, I said, hey, what less restrictive alternatives would we consider other than placing the kids in foster care? His answer was none. I didn't consider any of them, any less restrictive alternatives. Well, by definition, at that point, I should have won and the kids should have gone home. But I had to continue on and I had to prove that there was a less restrictive alternative. That's actually not the law, okay? But I had to do it to make sure that I won and to make sure that the judge sent the kids home to the mother, with the grandmother living there. So those are the main differences between the jurisdictional and the dispositional case. Now, a lot of judges will bifurcate, meaning they'll do the hearing separately if you ask your attorneys to do so, or they'll do them together. And the common practice is that they are done together. And there was a period of years where the jurisdictional and the dispositional hearings were done together, even if you didn't want them to be. And I got used to that, and I kind of made up a strategy in my questioning and presenting evidence across the
Wait, your voice keeps going in and out, Vincent. I got a text message from somebody watching saying they can't clearly understand your words.
Okay. So I got used to the strategy of the jurisdictional hearing and the dispositional hearing being done together.
Mm-hmm.
So I like them being done together, but every once in a while, an attorney asks for the jurisdictional and dispositional hearings to be done separately. So I hope you heard what the differences are between the jurisdictional and dispositional hearings.
I think some might not have heard that because your voice was very faint.
Can you hear me now?
I can hear you a lot better now.
Okay. You know what? My microphone here on the side was actually pointing in the wrong direction. So if you want, I can explain it again, or if somebody that's listening has a question, I can explain it again as well.
If you don't mind explaining it again, because they want me to share this video with their grandparents.
Okay.
I'm sorry.
No, that's no problem. The jurisdictional hearing and the dispositional hearing are two separate hearings. They are covered by two separate laws, two separate code sections in the California Welfare and Institutions Code. Okay? By the way, Georgette, if you ever can't hear me, just do your thumb like this, and I'll speak louder. Okay? Now, when you do the jurisdictional hearing, the test is the social worker has to prove a risk by a preponderance of evidence. Okay? In a dispositional hearing, the social worker has to prove by clear and convincing evidence that you're a substantial danger, and by clear and convincing evidence there are no less restrictive alternatives. Okay? And they have to prove that by clear and convincing evidence. Now, let me review the 3 burdens of evidence in California and in most states. Beyond a reasonable doubt, which is the prosecutor has to prove by 90% or more that something is true. That's not used in CPS cases. The next level down is clear and convincing evidence. It's only used in 2 places in a CPS case. And the first one is at the dispositional hearing, where they have to prove by clear and convincing evidence that you're a substantial danger, and by clear and convincing evidence that there are no less restrictive alternatives other than placement of the kids in foster home. All right? The jurisdictional hearing, they have to prove risk and preponderance of evidence. So if I look at the kid the wrong way, I could be a risk to the child. But I have to be one bad dude to be a substantial danger to a child. Not just danger, a substantial danger. Okay? And recently, maybe a couple months ago, I won a case. I got 7 kids returned home because I proved that the social worker did not prove by clear and convincing evidence that there was not a less restrictive alternative. As a matter of fact, when I cross-examined the social worker, I said, hey man, what less restrictive alternatives did you consider other than placing these kids in foster care? And he kind of looked at me like, he clearly didn't know what I was talking about. And he said, none. He didn't consider any less restrictive alternatives. Now, at that point, I should have won and the kids should have gone home right then and there. All right? But I had to go further and prove that there was at least one less restrictive alternative. And I put on it a witness, the grandmother, who said, Judge, if you send the kids home, I'll move in with the mother and watch the kids and make sure that there's no problems at home in terms of the children not being safe. Because it was a domestic violence case, and the judge was concerned that the mother was going to let the father back home or come to the home and visit. Okay? So those are the differences. Now, when I first started doing juvenile dependency cases over 30 years ago, the jurisdictional hearing and the dispositional hearing almost always was done separately. And it was done like that for years. About maybe 10 years into doing this type of law, there were a lot of changes in the code. And there was a focus on making money and saving money for the county, for CPS. And all of a sudden, a lot of counties started doing jurisdictional and dispositional hearings together to save time for the court and save money. LA was one of the last counties to start doing that, but they did it, and that was the rule of law for many years. A lot of judges now throughout the state, including LA, if you ask the judge to bifurcate the jurisdictional and dispositional hearings, they will do them separately. But the attorney has to ask, and of course, the judge has to agree.
Right.
I was a big opponent of combining the 2 cases because of the 2 different laws, the 2 different evidentiary standards, the 2 different legal tests. I was against combining them. But because I lost that battle, I developed a strategy in approaching these cases to make it my advantage to do them together. So I rarely want a case bifurcated to be done separately. And I like it when cases are done together. And there are many reasons why I like it. And, a couple of weeks ago, I was just having this discussion with another private CPS defense attorney who's very experienced. And we were having a discussion, and he disagreed with me. But after I gave him my explanation,
Mhm.
he kind of looked at me and said, I never thought of it that way, Vince. And it was one of those kinds of things that I took a bad situation and adapted to it and tried to make it my own and use it to my advantage.
Okay.
And in that case, and you were at the courthouse, Georgia, and I think you were even in the courtroom. In that case, with the lady with the mom with the 7 kids,
Mm.
I used, in a couple of times, I asked, I don't know if you remember this, but I asked the judge, we're doing the jurisdictional and dispositional hearing together.
Mhm.
I asked her a couple of times, and she said, yes, we are. Why? And at one point, she asked me, well, do you want to do them separately? And I was like, no. I want to do them together. But the county counsel who represents the social worker keeps objecting to my questions and saying that they're dispositional questions. But you told me we're doing the dispositional and jurisdictional hearings together. So if there are dispositional questions, I should be able to ask those questions.
That's right. Yep.
So my strategy in that particular case was I basically skipped over the jurisdictional part of the case and I went straight to the disposition because I knew that I was probably going to lose the jurisdictional hearing just based upon the comments that were made by the judge
Right.
in previous hearings about
See, but
what had happened in the case.
Mhm.
So I just said, in my own mind, I just jumped to the dispositional hearing and focused on that. Now,
Right.
just to make sure that the listeners understand, the jurisdictional hearing is to determine whether the facts the social worker has alleged are true or partially true.
Mm.
If the social worker proves that they're true or partially true, that doesn't mean you don't get the kids back. That means you get to go to the disposition hearing, and then they have to prove that you're a substantial danger and there are no less restrictive alternatives.
Mhm.
You get it?
Yes, I do. I was
Okay.
there.
So a lot of people, if you're a very experienced attorney in dependency or CPS law,
Mhm.
you know that the most important hearing is the dispositional hearing.
Yep.
The law is almost written to favor the parent. And there are a lot of attorneys
Yep.
that don't realize that.
Because they're
And
stupid.
sometimes I get the feeling maybe there's a judge or two that may not realize that because other attorneys don't argue that. And in that case, I don't know if I mentioned this to you. I think I did. The prosecuting attorney was an attorney where I had the same issue about 5 or 6 years ago in another courtroom.
The lady, right? You're talking about the lady? Yeah.
She argued in that case and in this case
The same.
that the test wasn't clear and convincing evidence and that it wasn't a substantial danger.
But you were aware that she was acting like a clown when you were talking about that, right?
Well, it doesn't matter what she's doing. I don't pay attention to what she's doing.
Mhm.
When I'm in trial, I'm communicating with the witnesses and the judge. That's it. I don't care what other attorneys are doing.
Mhm.
Okay? Because that's the easiest way for them to throw you off your game.
Exactly.
Okay? So here's a trick that a lot of attorneys use. You're asking questions of the social worker and you're making headway and you're making the social worker look bad. All of a sudden, the social worker's attorney starts objecting. That's to try to throw you off, right? Throw you off the game. So I don't even pay attention to it. I just listen to the judge's ruling. And if the judge rules for me, I keep going. If the judge rules against me, I make adjustments.
Mhm.
Okay? So in that particular case, the social worker's attorney was objecting, and I kept saying, Judge, I thought you said we're doing the jurisdictional and dispositional hearing together. Well, we are. Well, she said it was a dispositional question. That means I can't ask that question. And it was like, you're right. So then I just kept going at the social worker.
Mhm.
Okay, you get it?
I
But
get-
what happens is a lot of people don't understand the importance of having a trial at the dispositional hearing.
Right.
You could lose the jurisdictional part of the case. You could even work out a deal and plead no contest to the facts or amended facts, but you can have a dispositional hearing and win. Let me give you the classic easy example. And this used to happen all the time when I was a court appointed attorney, 30 years ago.
Mhm.
Kid is born with drugs in the system. Okay. And what I used to do, and a lot of attorneys used to do this, what I used to do is I would set the trial as far out as possible for the jurisdictional hearing. And then I would tell my client, I would say, hey, if you get in a drug program and start testing clean, I may be able to win the dispositional hearing and get you the kid back. So what would happen is we'd have the first hearing, the detention hearing, and then the case would be continued like about 6 to 7 weeks. And then my client's testing once or twice a week. And then if she's testing clean, she doesn't miss any, she doesn't test dirty, I've got 7 weeks of clean tests. Then we come to the jurisdictional hearing. I work out a deal for her, pleaded no contest on the jurisdictional phase only.
Mm.
And then I set the dispositional phase down the road for another 6 or 7 weeks. Right? Then I come back and my client has 14, 13, 14, 15 weeks of testing clean once or twice a week. And then I argue to the judge on that day, not when the day the case started, on that day, the social worker has to prove that she's a substantial danger
Mhm.
by clear and convincing evidence. Well, judge, she's been clean the last 14, 15 weeks. She can't be a substantial danger. She might
Oh.
be a danger. She might be a risk, but not a substantial danger. And I can now prove less restrictive alternatives. So a lot of my, mothers would be in a drug program, and back then, a lot of drug programs would take the mom and the baby together.
Mhm.
Well, that was a less restrictive alternative.
Right.
So I was able to win a lot of those types of cases in dependency court. So, you want to set up the case so that they can't argue that you're a substantial danger on the date of the hearing. Now, a lot of people don't realize this. This is another trick that prosecutors use. They argue that you are a substantial danger on the day that the case started. That's not the law. The law is that they have to prove that you're a substantial danger on the day of the hearing, on the day they have the hearing, not on the day the case started.
Right.
Okay. So if the person has been drug testing, going to a drug program, they can't prove by clear and convincing evidence that you're a substantial danger. Now, here's one of the things I've seen and I've heard. They come back and the judge says, well, 15 weeks, you had a big, you had a huge drug problem. I think you need to do another 6 months, right? And I'm not going to give you the kid back. Generally, when that happens, there is no trial. And the attorneys accept the judge's tentative decision. Truth be told, if you had a trial and you put evidence on, the social worker would not be able to prove that you're a substantial danger by clear and convincing evidence if the person was testing clean.
Mhm.
And if you brought in the person's drug counselor. All right. I'm not saying that the judge shouldn't be involved in the case. I'm not saying that CPS shouldn't be involved in the case. I'm not saying that there shouldn't be court supervision. I'm saying that the kid should be returned because there's not clear and convincing evidence that the mother is a substantial danger on the day of the hearing. Now, I see attorneys just give up that issue when I'm sitting in court all the time. And I'm not involved in the case, so I have no business saying anything. But if you have a case like that, you need to talk to your attorney about the pros and cons of doing what I do,
Mhm.
and that's having a trial and giving evidence, calling witnesses, witnesses that you may not even ever have thought about calling. All right?
Okay. Now, may I ask another question?
Certainly.
Okay. Um, I have some uh, parents who think they should weigh the. Um, so basically, if they should wait until trial to hire an attorney. They think that the court-appointed attorneys, is going to help them, and then they wait it out, weigh it out, weigh it out. But I told them sometimes you can't. I mean, oftentimes you can't appeal anything that's not submitted into court as evidence, right? So the attorney that you hire might not be able to appeal something that's not submitted in as evidence. Am I right? Or
You are correct. And this came up yesterday in a
Mhm.
case,
I came out three
in a
times today.
consultation.
Yep.
And the trial attorney that this person has plans on a strategy of doing this
Right.
way in the case. And the client wanted to know if I could do the appeal if he lost. And I said, yes, I could do the appeal, but I'm stuck with two things. I'm stuck with the evidence his attorney introduced into evidence, and I'm stuck with the legal arguments the attorney made in the trial court. So in this particular case, um, there's a huge need for medical expert testimony.
Hmm.
If his attorney doesn't call a medical expert to testify, I cannot at the appeal, at the appeal stage, introduce medical testimony. All right, once it's not done, it's not done, and he's waived that right. Okay, so don't think that, oh, I'm going to hire Davis to do the appeal, that Davis is going to fix everything. Davis is not a magician. All right, I can't fix things that are totally screwed up.
Hmm.
Okay, I can do a lot of things, but I'm not a magician.
Right. And you also still have to review the case anyways. I mean, you can't just go by what
Correct.
they say, because oftentimes what's written down contradicts what they're saying, and we didn't go by what. See, we know most of you guys are innocent, but what the social worker writes down in their reports, that's what Davis goes on by. And he comes up with a specific strategy to see, by asking you certain questions when you speak with him, to come up with a specific strategy to try to get your children back. Am I right, Attorney Davis? Or
You are correct. Today I did a training for an attorney that works with me. She's about to do a trial, and she kept saying to me over and over, which kind of concerned me, you know what? I never thought of that. I never thought of that. And she's an experienced, CPS attorney. So, it sometimes it pays to get a second opinion.
but a
I don't
lot.
know if I don't know if I ever told you this. Um, this happened many, many, many years ago when my wife was still alive. I went to the doctor, and the doctor told me, you need to have an operation. You need to have something removed. And I was like, yeah, that's fine. Okay. And my wife at the time, and I scheduled the surgery. And my wife at the time said, you're kind of a smart guy. Why you never asked for a second opinion? I said, why would I ask for a second opinion? I trust the doctor. And she said, well, I wouldn't trust, the doctor without getting a second opinion. So I found another expert in Pasadena to go get a second opinion. And the guy was, I sent my medical records over there, and the doctor was very nonchalant. And he's kind of laughing like, your doctor doesn't know what she's talking about. You
Mhm.
don't need this operation. And I said, well, okay, thank you very much. And I left. But I I didn't think he knew what he was talking about. So I found another expert to go to for a third opinion. And the third opinion, the guy was more thoughtful. And he says, Mr. Davis, I reviewed your records. He says, I don't think you need the operation, but I'm going to run some tests to make sure. He sent me to another doctor who ran some ultrasound tests and did some fine needle biopsies. And that doctor came back and said, you don't need the operation. And I went back to the doctor that referred me to him. And the doctor said, well, I think your doctor, who was an HMO, at the time, he says, I think they recommended that you have the surgery just in case for the rest of your life, you can't have any more problems with that particular organ. Okay, it was my thyroid.
Mm-hmm.
Okay, if they just remove it, you're not going to have any more problems, and it will save them money in the long run. I was like, save them money. We're talking about my health.
Right. They don't
And
care about your health.
I don't know if you know anything about the thyroid gland and how important it is and what the dangers are about having thyroid surgery. There are some dangers with it, believe it or not. And I realized that after getting 2 more opinions that I didn't have it. I didn't have the surgery, and that was maybe more than 20 years ago. No problems, and I didn't need the surgery. I say that to say this. These particular cases involving your children are probably the most important legal case you'll ever have. Okay? You'll ever have. And for you not to really get a second opinion, it's like me not getting a second opinion and my wife telling me, you're kind of a smart guy. Why wouldn't you get a second opinion? And she basically shamed me into getting a second opinion. And then I got a third opinion, and it was good I did.
Yep, I agree.
It was good I did. You know what one of the risks of having thyroid surgery is? You could lose your voice. Now, I'm a lawyer I'm a trial lawyer. How am I going to make a living with no voice? So anyway, a lot of people, I think you should consider at least consulting to get a second opinion, because everyone has their own reasons for doing things a certain way, and information and knowledge is power.
Correct. I agree with that. And I'm about to mention something to Louis Sauce right now. Sweetheart, I know you're upset. You're asking legal questions, and I think somebody here named Tessa French, she's responding to a legal question. But I think you guys should not give any legal advice out there. Please refer any legal questions to Attorney Davis. If you guys need to get a hold of me to go through Davis, you're more than welcome to call the office and ask to speak with me, and I'll be happy to hear your story and see what I can do to help you and get you an appointment with Attorney Davis. But please do not give any other legal advice out there. I'm begging you, because every case is different. You might not understand the whole entire case review on this person. Am I right, Attorney Davis? Or
you are? A lot of people are well-meaning, and a lot of people spend a lot of time in groups on the internet, and they feel that they've developed an understanding about the law, and it's very dangerous for them to give advice. They don't feel that way, but it's very dangerous, mainly because they don't know the rules of procedure and the rules of evidence.
Right.
I think I gave you a small lesson on evidence the other day, and you were kind of surprised, and you were thinking that justice shall be done, and I was trying to show you that no, justice isn't what you think.
There is no justice. We know that.
Well, justice isn't what you think. It's defined a different way, and it's controlled by evidence. It's controlled by the code of evidence. So, and here's the thing: you don't know the code of evidence, right? So you don't know what it takes. The other day, I think we had a meeting together with someone, and I told you this story about uh, my first year in law school, where a professor told us something that took me years to accept. And I didn't accept it until about 5 years after I became an attorney. I'm now 39 years, but it took me 8 years to accept this. Our system of justice is based upon the English common law system. And one of the foundations of the English common law system is that ignorance of the law is no excuse. It took me 8 years to accept that because where I was from, nobody knows the law. And that is tantamount to saying that since we don't know the law, we really don't have access to justice, or we really don't or won't get justice in the legal system unless we get a good lawyer. And that was it. In my community, where we grew up, and if you were arrested or had criminal involvement, there was only 2 or 3 attorneys that you wanted to hire, as your attorney, because they were, kick-ass attorneys. And one of them was Johnny Cochran. It was kind of it's funny now when I think back on it, but it was like I can remember having conversations with people as a young person, before I went to law school, like so and so would got arrested on something, and the advice was you better call Johnny.
Hmm.
That was a real thing. You better call Johnny. He was the man. And why was he the man? Because technically he was not proficient. He was a guru. He was a guru in procedure, he was a guru in evidence, and he was a guru in politics. So you got to have a good attorney. Justice isn't what you think. Look at my YouTube channel. I got a video on this. Justice is not what you
Hey,
think.
Attorney Davis, let's just talk about something from
Okay.
the audience, please. Okay. What? It's about Louis. Louis is it's like all over the place. Okay, so Louis. Okay,
Louis says I'm my own attorney.
right,
Louis,
and then I
Louis,
am
you're
telling
headed
my
for disaster.
story. Wait, there's
Louis is headed for disaster, my man.
right, and wait, hold on. I'm not an attorney, just another parent fighting. Oh no, that's Teresa. Okay, or Tessa. Sorry. He said something earlier.
Look, Rich Flame says, "Can Attorney Davis answer my question?" What's his question?
I'm trying to find. Oh, here it is. Should I get my? Here it is. He said, "Should I get my children to a safe space if they are investigating the dad in another case?" So
I don't
the children, I
understand.
guess, Rich Flame is a woman. I'm assuming she's the mother. She's asking if should I get my children to a safe space if they are investigating the dad in another case. Basically, if the dad is investigated in a criminal case, they might come after the children, right?
Oh,
So,
absolutely.
so I'm assuming that's what she's asking, but I could be wrong. Okay,
If that's what
okay. No, he said she's sorry about that, Rich. Okay, so he's the dad. Okay, I'm confused. Okay.
Hey, Rich, sometimes typing questions in a chat, we don't get the full flavor of it. Why don't you call that 888 number you see on the screen, bottom right-hand corner? Call today, make an appointment, and I'll talk to you, give you a free consultation.
Yeah.
Okay, because you're kind of asking an important question, and I'm not sure what you're asking or why you're asking it. A lot of times people ask me a question, and the answers that I should give or not give, they're not black and white. They're not red or green. Sometimes they're yellow. And it depends on the facts and circumstances of each case. I was talking to someone yesterday, and I saw the look. Georgette was sitting with me, and I saw Georgette look at me like she was surprised by what I said. And this is what I told the client. The client said, this was the conclusion of the doctor and the attorney. All right. And I said, well, why was that the conclusion? And the client didn't know. And I said, and this is what surprised Miss G, I said, the why is more important than the conclusion.
That is true. That was yesterday in the office.
So everyone that's watching, think about that.
Okay, I want you to read Louis though. If you know the law and read all the information about family court law rules, policy, and due process, like I do, you have no right to belittle my knowledge.
He's
We're
right.
not
He's absolutely right.
we're
Louis,
not belittling anybody's knowledge here.
you're absolutely right. I'm sure things will turn out good for you.
Yeah, I mean, good luck, Louis, whoever you are. You seem very aggressive with your approach, and you're not really listening to a lot of, like you mentioned earlier, you know the law. You don't know the damn law when it comes to CPS. You have
Louis,
no idea
Louis,
what the law is.
Louis, I've only been doing this 39 years.
So you really are
I
really foolish.
do not know everything. I don't.
Oh, yes, you do.
I
don't do that.
learn everything, new things every day.
You know the law very well, Davis. You do not
So
learn. You teach them a thing or two. No.
no. All right. Any other questions you have for me?
Wait. Tessa said, I have years of experience in these things, but I'm not a professional or expert. I can only give my experience. Okay. Louis said that, what? A Chin's case that is open on a parent that do not deserve it. Injustice wrong, where no color, where there wrong, there no color to that, only injustice. Some individuals in the chat agree with me. Well, happy for you. I'm glad they agree with you. I don't agree with you. And I'm telling you right now, you have no idea how to fight a CPS case. No one does. If you don't have the special know the jurisdictional law like the back of your hand, then you have no right to say you know the law. You don't know the law. I've been to court with Davis. It's completely different world. This is not family court. This is not even criminal court. This is worse than family court. This is worse than criminal court. So you guys really have no idea what you're saying. You might have an experience about your case or about what you've been through in life. That's called life experience. But everyone is different inside that courtroom. Everyone.
But here's a fair statement by Tessa. Tessa says, how do you know whether or not he knows the law? That's so judgmental and very demeaning. You have no clue if Louis is a high-end attorney. Well, I think he said he wasn't an attorney, but you're right, Tessa. We don't know if he knows the law or not. We don't.
Even if he knows the law, we have an attorney that was going through a custody case, and Davis know who she is. She handled the case on her own. She lost. She said, I'm an attorney and I can't believe that I lost my own case. She hired Davis to handle the case for her. And that's an attorney. Because when you're in the courtroom and you think you know the law, you become completely numbed because it's your case. You become too emotional to handle your own case.
Even if
you know the law. That's why.
There's an old saying. There's an old saying that you will hear from attorneys and from judges. The person that has himself as a lawyer has a fool for a client, or vice versa. The client who has himself as an attorney has a fool for as a lawyer, or something like that.
Wow. I guess Louis doesn't like me from the beginning because Louis doesn't know me. And it's probably somebody that hates me from a while back.
Hey, Louis, she can't make my reputation any worse. Don't worry about it, bro. I've been doing this for 39 years. 39 years.
Yeah, right.
I do CPS cases all over the country.
Hey, he said, Tessa said, hey, is this Deidre? I'm not sure if Deidre is using that name. Hey, Miss G, why are you so aggressive? This is public peaceful chat. Oh, sweetheart, I'm not aggressive at all. But you guys, do your thing. God bless you. God bless you. Do your thing. all I
Okay.
have to say.
Do you have any more questions for me? We're going over time on the
No,
office hours.
actually, no. I'm glad. I'm good.
Anybody in the chat have any questions for me before we go? Rich is Sashu from earlier.
Yeah, Louis, you better back up, buddy. Michelle spoke.
It says Rich Flame. Rich is Sashu from earlier, Attorney Davis. Rich, I don't understand that question, my man.
No, we spoke to. He already texted me. He explained. So Rich is. We spoke to Rich already. Remember, but don't say his story. It was the 12 kids. Remember?
No.
Oh my goodness, Davis. It's okay, Rich. I'll remind him after the show.
Lady P says Federal Rule 60 if judge violated due process. Lady P, this is not Federal Rule 60 doesn't apply to CPS cases.
Uh-huh.
Rich, I think you're going to call me and I'll give you a free consultation.
No, you already did, sweetie. You already did.
Did he call?
Yeah, I transferred. It was a 3-way call. I transferred so many calls to you today. You don't remember, but you did give him a free consultation today. It was me, you, and him on the phone on the 3-way.
Remind me, what was it about?
Well, I don't know if he didn't tell me I can talk about it, but he's the one that.
Oh, no, never mind, because his name is there. We don't want to talk about it.
Let's not talk about it. Yeah. But you remember, it's a lot of kids involved. Yeah.
All right. If nobody else has any substantive or procedural questions, we'll close down for Lady P. Can I come on the show? Sure. What's your email address? We'll send you the link. Lady P, put your email address in the chat. And Grace is the producer. Grace, are you there? Send Lady P an invite to come on the show right now. Grace?
I think Grace hears you.
Okay. Lady P, did you give me your email address?
I don't think she's going to give it to everybody, Vincent.
Well, Lady P, are you going to come on the show, or
I'm going to give them Grace's email address, and they can email Grace, whoever wants to be on the show. Okay, so for
Lady P, tell me yes or no. Do you want to come on the show right now?
Grace, if you
Lady P says yes. Okay. Lady P, we just posted Grace's email.
and Gibson wants to be on the show too.
Okay. Oh, you know what? Grace is telling me we have a 5:00 show. Okay. Lady P, do you see Grace's email? grace@vincentwdavis.com. If you email her your email, she'll send you a link on the show. Grace, send Lady P a link to get on this show.
Yeah, she did see it. Yeah. Man, some people are brutal.
Wait, I'm getting a private message. There's no email yet from Lady P. Lady P, are you there? Louis Sauce says, all that lady said is belittling, aggressive, and rude and disrespectful to my grief, and is sad that you are allowing her to act this way. Louis, wait a minute. I just
Wow.
lost. Louis Sauce, I respect your opinion. I apologize, but if you feel belittled or disrespected, I apologize, but maybe you shouldn't even watch the show. Unfortunately, in this country, fortunately, we have the First Amendment. And under the First Amendment, people can voice their opinions. You can voice yours, she can voice hers, and I don't regulate speech. Okay, Grace is saying we're going to have scheduling problems. Lady P, you can come on the next show. There's going to be a show at 5:00 on these same social media platforms, YouTube and Facebook. So if you send your email in to Grace, I will bring you on as a guest on that show. And that show is with two other hosts, Deidre Payne, and what was the other woman's name?
Oh my gosh. I'll tell you right now. Hold on a second. Patrick, I think it was her last name.
Well, it doesn't matter. Lady P, we're going to have a show at 5:00, and I'll bring you on. And for everyone else watching who wants to come on or ask questions, come on the 5:00 show, and we will bring guests on and answer questions. Louis says, can you send me a link, please, so I can speak to the lady that hurt my feelings about grief and legal knowledge? Louis, I don't mind sending you a link, although she's not going to be on the 5:00 show. She and I, me and Miss G will be together tomorrow. And and if you log on, we'll bring you on as a guest, and you can speak your mind to Miss G, and you guys can have a discussion then. Lady P says, okay, thank you, 5 p.m. tomorrow. No, Lady P, it's 5 p.m. today. The show is 5 p.m. Pacific time today. It's in 6 minutes. Okay, Tessa's mad. She says, I ask why she's laughing because this isn't a joke and was ignored. Tessa's nobody ignoring you. You wouldn't believe the number of questions and comments that are coming through. I'm trying to get Lady P on a show. Louis is upset. Louis Sauce says, I sent an email to you. You sent it to Grace or to me personally? I have her number. Now here's something, because there's a lady.
She said she wanted a payment plan, and I didn't, agree on it. So basically, Tessa is upset because I didn't get her a payment plan.
Hold on a second. Tessa says she's being ignored. Tessa, if you want to talk to me personally, call the number on the screen, ask the operator or the receptionist to speak to Attorney Davis, and I will speak to you. Tessa, the number is on the screen, bottom right-hand corner, 888-888-6582, and I will speak to you, and I will not ignore you. Louis, I'm not going to stop watching you because of her words, and her belittling has nothing to do with you. Thank you very much, Louis. I appreciate that. But she will still be on the show, so I just want to let you know. Lady P, gotcha. No, that's not the case. You don't want to call me? Okay. All right. Folks, Miss G, thank you very much. Folks, thank you for watching. Go back and watch this episode again. I give I think a decent explanation about the difference between the jurisdictional and dispositional hearings, the tests, and the evidentiary burdens. And keep that in mind when you're working with your attorneys, when you're facing those types of hearings. Tomorrow, remind me, Ms. G, tomorrow, let's talk about the 6-month review hearings and how to win those, okay?
Okay.
Alrighty, folks, I'll see you guys on the 5 o'clock show in a few minutes. Bye-bye.